If there's real estate outside the state, let's assume that you have real estate in Connecticut, and you have real estate in Florida, and you have real estate in Nevada, you have real estate in California. That means if you don't have a revocable living trust that owns all those properties, then at your death, it'll be necessary to have separate ancillary probate proceedings in each of those states where you have real estate. So not only would you have your original probate proceeding in Connecticut, assuming you're a Connecticut resident, you'd also need ancillary probate proceeding in Florida and Nevada and California, all those states where you owned real estate. I'm talking about those states where you own real estate and it's a probate asset. If that real estate is owned by your revocable living trust, however, there would be no need to have an ancillary probate proceeding in those other states. You'd be avoiding probate in those other states. That can save some duplicate paperwork and may be worth doing. Keep in mind, however, when I talk about avoiding probate and avoiding ancillary probate, I'm not really talking about avoiding the estate tax process. It could very well be the case that you have real estate owned in a revocable living trust in California, and you still might have to take care of the California estate tax return and pay any estate taxes that might be due to California on the value of that property. You see that in this chart, the three things I just talked about are in a different color, as kind of a bluish greenish color. And that is to indicate the steps that are avoided when you actually avoid probate. Now we're into another step called the application for a taxpayer identification number. And you see whether you have a revocable living trust or you don't, it will be necessary to get a taxpayer identification number for either the trust or the estate. Now, the taxpayer identification number is a number that a separate tax entity will get, and when that tax entity files an income tax return, it's supposed to use that number, just like we use our Social Security numbers on our individual income tax returns. So when you set up a revocable living trust and then you die, your trustee needs to get new taxpayer identification number for that revocable trust, and it will be necessary for the revocable living trust to file income tax returns for as long as the trust assets are generating income. Same thing if you don't have a revocable living trust. You've taken your executor's taken the will down to the probate court, gets appointed by the court, and now takes possession of assets, and in the process is putting the assets in the name of the estate, and the estate will be earning income, and the estate will need its own separate taxpayer identification number and will file its own separate, they call them fiduciary income tax returns. Keep in mind that one of the goals of the probate process is to protect the rights of creditors. So at your death, you have debts, and your creditors are entitled to be paid from your estate, and the creditors have rights. And of course, your executor is concerned about satisfying those claims, and if your executor doesn't do a good job of it, could potentially be personally liable for any claims that should have been paid, but for one reason or another were not properly paid. So the probate process has provisions in it that deal with the rights of creditors and protecting executors who do a good job of dealing with those claims. So if you're in the probate process, there's a certain amount of protection for creditors and guidelines for executors, and that means there's a safe harbor for executors to be protected if they act properly with the estate assets, but for some reason a creditor does not get paid. Maybe a creditor didn't provide the executor with notice. And there are procedures within the probate process whereby the executor can protect himself from surprises that may pop up, creditors that weren't known about. When your estate plan revolves around a revocable living trust, however, you're outside the probate rules and regulation relating to creditors' rights. And so it's much harder for the trustee of the revocable trust to get the protection from creditors that the trustee would like to have. So that's one of the disadvantages of avoiding probate. The next thing on the list is the process of taking possession of the assets. Of course, if you have a revocable living trust and you've done a good job of transferring all your assets to the trustee of the trust, that means the trustee already has possession of the assets at your death and doesn't have to go through the process of collecting them. On the other hand, if you don't have a revocable living trust, if you're doing things by will, that means your executor's got to be appointed. That means your executor's got to go through the process of collecting the assets. He's got to figure out where they are, take the court decree or the fiduciary certificate. That's the evidence that he's executor to the bank and close out the decedent's bank accounts and collect the assets in that way. So in that way, a revocable living trust can make things easier for the survivors. The trustee's already got possession of the assets at your death. And then there are notifications to insurance companies and things of that sort that you have to go through that process whether you have a revocable living trust or not. In other words, the trustee has to make the claim for the death benefit if the trust is the beneficiary, or the executor has to make the claim for the death benefit if the estate is the beneficiary. And of course, there are always tax elections and tax planning decisions that need to be dealt with, and that's true whether you have a revocable living trust or not. And yes, it's a good idea as soon as your death occurs for the trustee to make a list of the assets, that's the inventory, or for the executor to make the list of the assets, that's the inventory. The difference is that in the living trust situation, there's no obligation to file that list with any court. Where there is no living trust, however, at least in Connecticut, there's an obligation to file the list of assets or the inventory with the probate court. Of course, whether you have a living trust or not, as we mentioned before, the trust will be a separate taxpayer, or if there's no living trust, the estate will be a separate taxpayer, and in each case, income tax returns will be required if there's income being earned on those assets. The return and list of claims, I mentioned before, the procedure for dealing with creditors. And in Connecticut, after a certain period of time goes by, it's 150 days after the executor is appointed, the executor is supposed to file a report with the probate court called a return of claims and list of creditors. That's to identify the creditors who have made claims during that period and how the executor has disposed of those claims. That is not required if probate's avoided. There's no need to file that list in the probate court. Now, that's a disadvantage as far as revocable living trust is concerned and as far as avoiding probate is concerned, because without that list on the record, there's no telling that any one of those creditors could come and make a claim against the executor someday. And in either case, the Connecticut estate tax returns would have to be filed if you're a Connecticut resident, and I believe that's true in any other state that has an estate tax return. Whether you have a revocable living trust or not, it would still be necessary to file those state estate tax returns. In the next segment, we'll continue the discussion of revocable trusts and go on to discuss reasons for creating them.